Hey everybody, John Skiba here. It's Thursday night, so we are here doing the live stream with the Consumer Warrior channel. Appreciate all those who are going to be tuning in tonight. If you are new to this live stream, if you have questions relates to debt collection lawsuits, bankruptcy, garnishment, and all the other list of horribles out there as it relates to debt collection, go ahead and put them in the chat box there, and we'll put them up on the screen and we'll discuss. I have to give all my caveats, and I'm sorry I have to do this each and every week. It's annoying to me as well. But nothing that I say here can be used as legal advice. I don't know the specific facts of your case. We've likely never met. If you need an attorney, you should contact one in your state. I practice law in the state of Arizona. I don't know the laws in all the other states, but I do know junk debt buyer cases. I deal with a lot of them. I've done almost 500 trials against junk debt buyers. There's a lot of just constant information and constant themes between them that we like to discuss. I also am a bankruptcy attorney, so we discuss a lot of those things. But again, nothing here creates any type of attorney-client relationship, and it doesn't include any type of legal advice. It's just information. Take it for what it's worth. Some lawyer on YouTube. So with that being said, wow, Dave Lamb, always here for me. I appreciate you, Dave, again, supporting the channel. And for those who support the channel and this is helpful to them, because that is my goal, is to provide help to people who are battling, particularly junk debt buyers, where it doesn't make sense to hire an attorney, or maybe they're one of these little pesky Midland funding lawsuits where they're suing you for $800 or something ridiculous like that, to provide that information. I thought, though, YouTube, you probably saw earlier this week, I've launched a private Facebook group, essentially a membership component to the channel. This would be a place where there can be more interaction between all of you who are going through this and have tried some of these things, kind of things that have worked, things that didn't work. I'll be involved with this as well. But I put a link there in the notes. You can click on there. It is a paid membership. It's a fairly nominal fee each month. I got a little bit of grief in the comments from that. Just my idea behind this is that, man, look at Dave, new member already. Awesome. Appreciate you doing that. Oh, and Marcos, man, you guys are here each and every week. I sincerely appreciate your support of the channel. So as far as my idea behind this, it's going to be something I think can be very beneficial, because I see some of the comments and some of the discussions that are going on there in YouTube, where some of you have tried certain things like compelling arbitration and it's worked. Other people are just, stuck with discovery. And I see some limited interaction going on there. I think it could be a benefit if we get a big group of us in a private YouTube or private Facebook type group where the interaction is a little easier. So that was the idea behind it. So, all right, we are going to, again, if you have questions, go ahead and put them on the side. We're going to go over ahead and discuss them. Before I jump into the questions, I did want to tell you, I know that it can be rough, particularly you're representing yourself in debt collection cases. It just takes over your life. And things don't always go your way. Today was a rough day for me. I had a couple rulings that I really thought we had strong arguments in certain aspects of cases, and a court ruled against me. It happens to me. It happens to all of us. It happens to every attorney out there. If you ever meet with an attorney and they tell you they win all their cases, they're lying to you 100%. Because each case, even cases like this, have their own variables. So just something to think about, that, if you do have a setback, if you have a ruling that goes against you, what I have to do, even though I get frustrated by it, is immediately start thinking, okay, how does this change the strategy? What other ways can we approach this? If it's a bad loss or a big loss or something like that, then maybe you have to look at like settlement or bankruptcy. You kind of have to look at all the tools that you have available. So anyways, appreciate everybody tuning in. Let's go ahead and jump into some of the questions. Looks like we have a bankruptcy one here first. I've got to get myself up and above the little thing here. From Arizona, do I need to report a new job to my trustee? Good question. So this is a bankruptcy question. There is a trustee that is assigned to every bankruptcy case, whether it's Chapter 7 or Chapter 13. The trustee's job is to oversee the bankruptcy, in essence, review your documents, They've got to confirm your identity. They're going to hold what's called we call it a 341 meeting, which is the meeting of the creditors. They usually put you under oath and ask you if the information you submitted is accurate. But probably one of their main jobs is to look through your documents, your bankruptcy documents, to determine if you have any assets that can be liquidated and sold for the benefit of your creditors. Or in a Chapter 13, they collect the payments that you're making and then make a distribution to them. And so the question here, do you need to report a new job to the trustee? It depends on what chapter you're in. If you're in Chapter 7 is more of a backwards looking process. They're really concerned mostly at the day that your case was filed with the bankruptcy court backwards, as far as your employment, your income. There are a few exceptions, but mostly it's looking back. So in most cases, if you have a new job in a Chapter 7 case, if you filed Chapter 7 3 months ago and you're just waiting for your discharge, you change jobs, that's not really something the trustee is too concerned about. If you're in a Chapter 13, though, it's a big deal because Chapter 13, the idea behind it is that you're going to contribute your disposable income to your creditors for however long your plan is, 3 years, 5 years. And so if your income changes, that could change what your disposable income is during that time period. So you have to amend what's called Schedule I, which is the income. See how that works? Schedule I, income, it all works out. The Schedule I is where that has to be updated to show what your income is, your deductions, all that kind of stuff. So hopefully that helps out. Marcos, thank you for becoming a member here. For any of those who are just joining us, we've started a new a membership component to the YouTube channel, and it's going to have a private Facebook group in there. There's more information about that on the site, on the channel, and as well as in the chat here. So, all right, let's see here. For pay plan under what you can expect section, no mention about settlement is voided or reverted to the original amount if not met as listed. I'm not sure if I quite understand the question. Payment plan. Isad, I'm going to ask you to clarify the question just a bit. I don't want to send you down a wrong path or discuss something that's not going to be, I think I'm maybe getting it here. So if there's no mention of settlement is voided or reverted to the original amount if it's not met or listed, I'm going to ask you to clarify that just so that I don't want to take you down a wrong path on that. All right, let's Chandra here. How do you remove a satisfied judgment from your credit report? So there's a couple things going on here when you have a judgment. If a court enters a judgment against you, they have the physical judgment, and then often that document is recorded with the county recorder in your state, or the equivalent of a county recorder, essentially where all these public documents are kept. And in some instances, it can act as a lien against real estate if you have a judgment that's done there. And then once you pay it up, most states require that they file what's called a satisfaction of judgment, and they submit that to the court, and they submit a copy to the county recorder so that if people are searching for it, they can see that the judgment has been satisfied. So, but as far as it showing up on your credit report, judgments do not show up on credit reports. That's something that's still relatively new. It was like summer of 2017 when the three big credit reporting agencies, TransUnion, Equifax, and Experian, they changed the rules. They said, we're no longer going to report civil judgments under the public records section of your credit report. The reason being is that it was very hard for them to verify the information on there. If there's John Smith has a judgment against him, well, there's a million of them in the United States, and so there was really no way for them to make sure that they were always tying the correct judgment up to the right person. So they just said, we're not going to do it. No more judgments will show up on the credit report. And so if you look at the public records section there, the only things that generally show up now are bankruptcy filings and sometimes federal tax liens. But beyond that, the judgment's not going to be there. The underlying debt may be there, though. And that's something where you would want to get them to update the credit report. And if they haven't done it, you could submit a dispute to the credit reporting agencies to have them do that. If they don't update it at that point, then you can contact an attorney like my friend John Watts in Alabama, and he can help you with the Fair Credit Reporting Act type matter. So hopefully that helps. Frankie, thank you again for supporting the channel right here. Chandra had a quick follow-up. let's see right here. Buying a house came up in a creditor search and it was paid, and you're in Arizona. Okay, so if it was paid, you need to reach out to the original creditor and or the judgment creditor, whoever has the judgment against you, and get them to file that satisfaction of judgment. The law requires them to do that like quick. So the fact that they haven't done it, if it's been sitting out there for a while, that's a big deal. Put some pressure on them to get that done. So, all right, let's see here. Usad, I feel bad that I'm not answering your question all the way, but I'm going to come back to it because I think I kind of know what you're talking about here. If you're on a payment plan, here's what I'm taking from it. You can give me the thumbs up. If you're on a payment plan, if there's no mention as far as if you don't follow through with the payment plan, what happens? Does it revert back to the original amount? So I'm going to bring this up in the context of a stipulated judgment. So often, if you're dealing with a debt collection lawsuit, you agree to settle it through a stipulated judgment where they're going to take long-term payment plans. For whatever reason in Arizona, we're seeing these all the time now. They used to want the lump sums, and it seems like now every time they come back with a counteroffer where they're wanting payments over like 2 years or 3 years, but they want a stipulated judgment where essentially you sign off on the judgment for a certain lesser amount, and in exchange, they agree not to try to collect on it. As long as you're making the payments, they don't do anything, but if you don't, then they can come after you. Usually there is going to be a term in a stipulated judgment like that. If you stop making payments as agreed, they're going to be able to take the judgment, and it usually does revert back to the full judgment amount. So if you're getting sued for $5,000 and you settle for $2,500 over time, you stop making payments on it, often it reverts back to the $5,000, and sometimes they'll even have terms in there where attorney's fees and interest will be added on top of it as well. If you're going to get into a payment plan with a creditor, I generally recommend getting some kind of grace period built into it, so that if it's due on the 15th each month, put in there that you get a 5-day grace period, like if it lands on a Sunday or something where it's hard to make the payment, so you're not worried about that. I would get that kind of stuff built into it, but if you're running into trouble, reach out to the creditor early on, rather than just letting it lapse and causing yourself a problem right there. So, all right, let's see what Frankie has to say. I settled account with Midland Funding. I forwarded the certified mail to all the credit bureaus on the settlement. The credit bureaus never updated the account, and now Portfolio Recovery placed a collection. So Frankie's wondering what he can do here. Well, so you settled the account with Midland. Part of my question would be, what did the certified mail that you sent to each of the credit bureaus, what did it say? And one, I should back up a little bit. Your credit report on a settlement is not going to be updated until you complete the settlement. So if it's something where you're doing monthly payments over time, you're not going to get an updated report until you're actually done with that, because kind of like the last question, if it falls through and you're not able to follow through with that, they're not, they want to have the higher amounts there. They don't want to show it zeroed out. So, but if you have settled it and it's done and you've paid it, and I always say give it 30, sometimes even 60 days, 2 cycles for them to update it. You need to dispute it through the credit bureaus. There's going to be different opinions on best ways to do this. The most efficient way to do it is to log in to each of those 3 credit reporting agencies, Equifax, TransUnion, Experian, and submit a dispute to any of those that are showing an incorrect information. They then have 30 days to reach out to the creditor to verify the information, and then they'll then report back. I've done this on my own credit report, and they're pretty good at it. I mean, it's all automated, but they're sending you emails and information saying, hey, we've reached out to Midland, we're waiting for them to respond to us, or they've responded and it's been corrected, or they've decided to keep it, that kind of thing. So that's what I would do. Is I would dispute it through their actual processes. Just sending a letter alone likely won't do it. So, all right, let's go to Leonard here. Working on some written discovery for a Portfolio Recovery Associates lawsuit. Can you point me towards some online resources for writing written discovery? Yes, I can. This question is, it's like I planted this question here. I have all my online tutorials. You can check that out. If you look at the top of the chat over here, I've got them, I'll show them right here. It's at this consumer-warrior-project.thinkific.com. I have one there on using written discovery as a way to win your debt collection lawsuit. And that one there is more about sending discovery to the debt buyer rather than you responding to them. I am going to prepare a course that's more focused on how to respond to what they're sending you. This one is set up so that you can go there and get the tutorial. I've got some templates in there that you can use. And I always say when it comes to discovery in these cases, always remember that the debt buyer bears the burden of proof. If you're getting sued by a creditor, the less evidence they have, the better it is for you. And so the mistake I see people do is they get the complaint or they get their initial disclosures and they're looking at it and they're like, wait a minute, this doesn't match up. That it doesn't have my name. It doesn't show that my account was transferred. They have the wrong balance. They have all kinds of problems with it. And you're outraged. And so you're like, I'm going to force them to go get all these things to try to show that they don't have it. That can be counterproductive for your case, because it may be that the debt buyer doesn't have that information. They never got it. They never requested it. And then by you forcing their hand, now they're actually either going to have to go get it, or maybe they'll bring in documents that you weren't anticipating. If you get to trial and they don't have all the documents, or if they don't have particular witnesses, that's good for you. Your job as a defendant is to sit back and punch holes in their case. They've got to come in and establish all the elements. You don't have to disprove anything. And so you've got to use discovery in a very kind of surgical way, rather than just letting it, than just saying, hey, I want all these documents and that, because I've seen it actually kind of blow up on people a little bit. So that would be a good place. I always say it's a good idea to look at the rules in your state, the rules of civil procedure. One of the best places for that is the Legal Information Institute. It's a Cornell Law School. Cornell Law School's website is all devoted to the rules from every state. They have a search box. You can put that in there. Google Scholar is also good for that. The rules that relate to written discovery, in most states, the rules 33, 34, 36. So you could kind of just, look up interrogatories, requests for production, requests for admission, that kind of thing. So, all right, let's see here. I was right with the Assad there. There was over a settlement plan that was not paid completely. Generally, if it's not paid completely, it'll revert back to the higher amount. So that's why it's important to try to pay off the settlement under the terms that are agreed, or communicate early and often with the creditor to try to maintain that settlement so that you don't run into any issues there. Leonard, and you, of course, yours is responding back to them. I don't know any resources like things that I put together. That, like I said, I'm doing that one right now that's in the works. I know that doesn't help you today. But in responding to written discovery, what I always tell people is a lot of times I see creditors who will ask for information that is either protected or not discoverable. They'll start getting into, really what they're trying to do is get information to be able to collect on the debt. Like I saw, I've seen them send over to self-represented people requests where they're like asking for your bank account information, social security number. They're wanting to know the name of your employer. Those things in most cases are not relevant. They might be relevant if they have a judgment, but if they don't, it's none of their business where you work or what your pay is, that kind of thing. So I will try to find some resources, and if I find any, I'll put those in the notes until I put something like that together. But that is something. The one little bit of information I will give you is, in most states, you've got to be really careful when it comes to requests for admissions. So generally, there's three types of written discovery. You're getting requests for admissions, you get requests for production of documents, and interrogatories. Requests for admissions in most states, there's a timeline to respond to them. It's usually 30, 40 days, whatever it is in your state. If you don't respond to them timely, they're deemed admitted, which is harsh. And usually these are just yes, no questions. And so they'll do things like admit that you owe us $7,820. And they'll say admit or deny. Or they'll say admit that we're the true owners of this account. and people will not respond to them timely, and then the court will deem them admitted and the case is over. So something to be careful about. All right, let's see what Albert has to say. How long is the process as far as time frame between getting served to there being a court judgment? I'm trying to figure out how much time I have to save money to offer a settlement. This is a really good question, particularly if you're being sued by an original creditor where the defenses aren't as great. And I often recommend settlement when you're looking at an original creditor lawsuit. This will depend on your state too, because the default process, if you're just to do nothing, let's say you got served. I'm going to use Arizona as an example because I live and practice in Arizona. In Arizona, you get served with a complaint and summons. The summons will say on it, you have 20 days to file a written response with the court. If a person gets served and they don't file a response within 20 days, then the creditor will file what's called an application for entry of default. In Arizona, the court then gives you 10 business days from the day that they served that on you to file an answer. It's kind of a grace period. A lot of states do not have that at all. Federal courts don't have it. Most states don't have that. Arizona, they give you somewhat of a grace period. And then if you don't file an answer within that 10 days, they'll file a motion for an entry of default judgment. So with that being the case, then a judgment could be entered. So if you did nothing, in most jurisdictions, you're looking at anywhere from 30 to 60 days before a judgment's to be entered. If you need to buy some time, or if you have any disputes at all, you can always just file an answer with the court. Filing an answer with the court will buy you usually several months. Even if they come in with like a motion for summary judgment fairly quickly, it'll buy you several months if you just file a motion with file the answer with the court. That'll allow you some time to negotiate, put some money together, and try to get a better response on it. So, all right, let's see. Thought I saw a couple here. This is a good one here. I asked for a master purchase agreement and he objected. What do I do next? So this is in the context of a junk debt buyer lawsuit. In the documents that are attached to it, there is usually a bill of sale or assignment, just a one-page document, usually a couple paragraphs, and it basically says, these two entities transferred some unnamed accounts that are listed on Exhibit A. You turn to Exhibit A, and there's usually nothing there, and they're saying, this is how we know that we own it. That's what they'll tell the court. This is it. This one-page document. This, several thousands of dollar deal. Even tens of thousands of dollars. They're saying, here it is. We did the whole thing on a two-page piece of paper. No, they didn't. There's a document called the master purchase agreement. Sometimes they're called forward flow agreements. And so it was a good thing to ask for. I always recommend asking for this through written discovery. They will object every single time. I work against the same attorneys all day long. And when I send these over, I get the same objection every single time. So what you then have to do is you're going to have to get the court involved to turn that over. This is when you're also going to need to go back and look at your rules of civil procedure related to requests for production of documents. Because usually there's a term, they'll have some provision in there where if the other side isn't provided to you, they may require you to reach out personally, to call them on the phone, send them a letter or something, essentially a good faith effort to say, hey, look, I think you need to turn this over. They're always going to say, hey, it's irrelevant, which is ridiculous. This is the document that gives them their rights to even be in the lawsuit. And so I always kind of laugh at that when they say, it's not relevant to these proceedings. We wouldn't be here without that document. They've got to turn it over. But for that document, the debt buyer wouldn't be in court. And so, or sometimes they'll say, oh, there's private information there. Well, there's private information in a lot of documents. The court's still going to require them to turn it over. Even if they have to redact some of it, they're going to be required to turn it over. So once you do that, then the next step is filing a motion to compel production. File it with the court, send a copy over to them. Basically, you're letting the court know, look, we've requested these documents. I've tried to play nice. I called them up, or I sent them a letter like I'm required to do. They're ignoring me. My experience is courts are going to require them to turn it over. It is a central document to their ability to bring these lawsuits. And for them to say it's just not relevant or that it's somehow privileged, I haven't seen courts uphold that. So that's what the process would look like. I can tell you too, kind of the dirty little secret, most debt buyers will dismiss your case before they'll turn that document over. If you get an order compelling them to turn that over, most will then reach out to you and say, hey, we'll just drop this because they don't want that out in the public. So, all right, let's see what W. Sims has. I literally just got served from Capital One Bank for a credit card 3 years ago that was charged off. I'm in Texas, wanting to know what to do. So the first thing I would do is look at the summons and complaint, the summons that came with it, because that will generally tell you how much time you have to be able to respond to it. You're filing an answer or response to the complaint or petition, whatever they call it in your state, is going to be the first key to it. You know, when it comes to original creditors like Capital One, generally the approach I take, unless there's like an identity theft kind of defense or something like that, they're hard cases to win. Presumably, they're going to have the documents, the witnesses, everything they need to be able to prove their case. And so it's not something where, you know, like a debt buyer case where they're just a mess from top to bottom. These cases, they're probably going to have what they need. And so it's generally not to your benefit to go to trial on something like this. Because often if you go to trial and they're represented by an attorney, which they're going to be, not only then do you get hit with the full judgment, but you're going to get attorney's fees cost, and it's going to just balloon up. So I would recommend taking a settlement approach. Sometimes you need to file an answer if it's something where they're not responding to you or you're not getting a settlement that works for you in place. You can file an answer, buy yourself some time. That's going to put you in a better spot. The great thing is you're in Texas, and to my understanding, Texas does not have wage garnishment laws. It's not permitted. So I'm always interested to how creditors collect judgments, because that's basically the only way they do it in Arizona. So, all right, let's see what else we got here. You know what? This is follow-up. This is extra credit here using 106. Rule 106 is a rule of evidence, the completeness rule that basically says if a party is going to introduce a portion of a document, they've got to introduce the entire thing. So if you look at the bill of sale and the assignment in debt buyer cases, they often will say Exhibit A at the top, Exhibit 1 or something. Those documents themselves are actually exhibits to something, a larger document, and is generally the purchase agreement, the forward flow agreement. And so it's a good rule. That's a next level type stuff here. In looking at the rules of evidence and stating, look, you can't just have a big stack of documents and pull one document out and say, well, we'll submit that. They've got to submit the whole record in fairness for you to be able to look at. And, I always argue, it doesn't mean that the whole thing's going to come into evidence, a trial or something like that, but you're at least entitled to take a look at it. So, all right. Let's do a couple more. See what Lynn has to say. I was headed for a jury trial. It didn't compel. The judge ordered the lawyer to file for summary judgment. Can I still ask for discovery? You're in Massachusetts. Gosh, that's bizarre if the judge required them to file a motion for summary judgment, just because, what does the judge care? The judge is just there to just, they're the umpire in this. Yes, you can still request discovery, assuming that the court did not set a discovery cutoff. And that's, again, where you're going to have to go back to the rules in your state. Again, the Legal Information Institute at the Cornell, I think it's just cornell.edu. If you go there, you can do a search for your state, rules of civil procedure. So that's something to take a look at as far as, if there's a discovery cutoff. Because sometimes the judge will say, okay, July 15th, no more discovery after that date. As long as there isn't a deadline like that, you should be able to do it. So, all righty. Thanks. I've won 2 of my cases in the Justice Court using the arbitration motion to compel. Awesome. That is one of our tutorials, and a lot of people have had success with that. I think it's a good approach to take on it. So, all right. We're about at a half hour here. I think we're going to wrap that up for this Thursday night. Thanks for all those who have participated and contributed, and all for the new members. Dave and Marcos. Again, the link's there. It's also right on the YouTube channel where it says join or membership on the mobile application. That'd be awesome to get more people involved in the Facebook group where we could kind of take those discussions at a more deeper level in that private Facebook group. Again, appreciate you all watching tonight, and we will catch you next week.